The 1984 model law grants wide powers to the tribunal to grant interim relief. Article 17 states, unless otherwise agreed by the parties, the tribunal may, at the request of a party, order any party to take such interim measures of protection as the tribunal may consider necessary in respect of the subject matter of the dispute. The tribunal may require any party to provide appropriate security in connection with such measure. It is a short provision, but it gives great latitude to tribunals. There is no limitation of the relief that a tribunal may grant. It is accepted that a tribunal may grant a very wide range of interim relief. The 1984 model law does not prescribe the test to be applied by the tribunal. It is open to the tribunal to determine the test. One possibility is to apply the test for interim relief used by the courts in the seat of arbitration for litigation in that court. However, where the seat is chosen as a neutral venue and the dispute otherwise has no connection to the seat, one has to ask oneself whether the parties, in opting for international arbitration, should be bound by the test applied by the local courts in that seat for litigation in that court. I sat as an emergency arbitrator in Singapore dealing with an application for interim relief. One party was from Germany, the other India. It concerned a project in India, and the governing law was either Swiss or Indian law. Seen in that context, the test applied by the Singapore courts to the determination of interim relief in litigation in that court did not jump out as the most obvious choice. One other choice is to look to the governing law that is to apply to the substance of the dispute and to apply the test for interim relief used by the courts of that country. However, where, as is often the case, a governing law is chosen not for its connection to the parties or to the subject matter of the dispute, but as a neutral law for transnational transactions, one has to ask again whether the party should be bound by the test applied by the local courts in that country of the governing law for litigation in that court. Particularly so if the parties had chosen not to arbitrate in that country, but in another jurisdiction. If the law applied by the courts of the seat or of the governing law should not apply, what options are we left with? Gary Bourne, in his book on international commercial arbitration, argues for the application of transnational standards for the determination of interim relief in international arbitration. Where are these standards to be found? Bourne suggests they may be found in the determinations made by other arbitrators in international cases. As amorphous as this may sound, there is much to recommend this. Parties choose international arbitration as a transnational means of resolving disputes arising out of transnational transactions. They often choose a neutral governing law that may have no connection with the parties or the subject matter of the dispute. They often choose a neutral seat that again may have no connection with the parties, the subject matter of the dispute, or the governing law. Viewed in this context, there is much to recommend a transnational approach to the test for determination of interim relief rather than the application of standards used by the law of the seat or of the governing law for litigation in those courts. So how do we define this transnational test? There is wide acceptance internationally that the test has three principal elements. First, whether the claimant has a prima facie case on the merits. Next, whether there is an urgent need for interim relief. And finally, whether the applicant will suffer serious or irreparable harm if the emergency relief is not granted. Let me focus on one aspect of the test, the issue of irreparable harm. What is irreparable harm? Some commentators have opined that irreparable harm is one that cannot be compensated by a monetary award. However, in commercial disputes, harm may almost always be compensated in monetary terms. In one case that I had to deal with as an arbitrator, this element became a particular issue of contention. The case concerned the injunction of a call on a bond. The applicant for interim relief sought an interim injunction on the call of a bond against the beneficiary of the bond. So, on its face, the applicant could be compensated by an award for the return of the amount of the bond if the injunction was not granted. The beneficiary of the bond, against whom the injunction was sought, was in India. To get around the hurdle of irreparable harm, the applicant argued there was a real risk the Indian courts, the likely place of enforcement of any award to recover money paid out under the bond, may not enforce the award, or that enforcement would be subject to unreasonable lengthy delay. So the applicant specifically asked me to make a finding that the Indian courts would not enforce a New York Convention award, or that the enforcement process in India would be subject to unreasonable delays. This was not an easy decision to make. Fortunately, I was able to avoid such a finding by determining that irreparable harm need not always be one that cannot be reversed or compensated by monetary award. I found that tribunals need not set the bar for irreparable harm that high. In considering the issue, a tribunal should balance the harm to be suffered by the claimant, if the emergency relief is not granted, with the harm the respondent may suffer if it is. Where the respondent will suffer no or minimal prejudice if the relief is granted, it may be appropriate to grant emergency relief to maintain the status quo, even if the harm the claimant may suffer is not irreversible or may be compensated by a monetary award. In the case before me, so long as the bond remained valid, the respondent would suffer minimal harm with respect to the amount covered by the bond. After considering the balance of interest between the parties, I granted the injunction, but on condition that the applicant extend the validity of the bond to ensure that it remained valid, and provided a written undertaking to indemnify the respondent's losses flowing from the order should the respondent ultimately be found entitled to make the call on the bond. I raise this example to illustrate the point that the adoption of a transnational standard for determination of interim relief gives the tribunal the flexibility to determine interim relief to suit the subject matter of the dispute as may be appropriate. This is what the 1984 model law mandates. And it is for this reason there is criticism of the introduction of a test for interim relief in the 2006 amendments to the model law.